lie, the election had been stolen. And his lawyer just confirmed that Eastman was definitely working for Trump at key moments in the days leading up to January 6th. The committee first subpoenaed Eastman back in November, and he has been dodging and fighting them ever since. Eastman pled the fifth 146 times when he appeared before the committee last month, and he's been trying to keep his papers out of their hands too. But a judge just dashed his hopes on that. Michael Isikoff, chief investigative correspondent for Yahoo News, is covering the latest developments on the Eastman case, and he joins me now. Michael, set this up for me. What documents did the committee want access to, and how is Eastman trying to block them?
Well, there's something like 19,000 emails that have been identified that were exchanges between Eastman, who was then at Chapman University in California, and Trump and his legal team. So that is a pretty substantial body of evidence right there. The committee subpoenaed Chapman University for these emails because they were apparently on a big chunk of them were on the Chapman University server. Eastman went to court to try to block the committee from getting his emails. This is just a few days after he invoked the Fifth Amendment 146 times when he was deposed by the committee. And now Judge David Carter in California is hearing this dispute. He ordered that Eastman and his lawyers produce a privilege log identifying which of those emails they want to claim were covered by attorney-client privilege. But the most interesting development in the hearing the other day on this case was the lawyer for Chapman University, who said in court that all of these emails were improper, unauthorized, and he likened them to contraband because this was a Chapman University server. It wasn't Eastman's personal server. So the idea that you could have attorney-client communications on a third-party server is not likely to fly with Judge Carter.
Right. So he's emailing on his chapman.edu email address in the midst of this frenetic period of essentially coup plotting with the Trump folks. They're sitting on the server. I want to read from your piece here because I thought it was striking as well. The lawyer for Chapman University, whose computer hosts emails, told the judge the professor had no rights to use university email system for his representation of Trump because it was partisan work on behalf of a political candidate, a violation of the university's status as a nonprofit. Any use by Eastman of Chapman emails on behalf of Trump was, quote, improper and unauthorized, said Fred Plevin, a lawyer for Chapman. I likened it to contraband, as you just said. So you've got the actual possessors of the document saying, have at them, these are contraband. And now the claim that he's trying to make is that these were protected by attorney-client privilege. Is that right?
Right, exactly. And I mean, Chapman's lawyer has argued that, Eastman's lawyer has argued that Chapman knew that he represented outside clients. Obviously, Chapman is disputing that and disputing that he had the right to do it. But, it's a bottom line reminder for everybody that, if you're doing personal work, don't do it on your employer's computer server because they own the material, not you.
Yeah, it's a news you can use segment here. Don't get exactly. Go sign up for a Gmail or a Proton Mail account. Very easy to do. What do we think is in the documents? I was shocked by the number of that, and I have to say, in following your reporting, my sense of his centrality ascended insofar as it seemed like he might have been a little bit of an arm's distance guy who got this in front of them, but it seems like he was fairly central to the whole legal plotting.
He was. There's no question. John Eastman, who is, was a law professor, former clerk to Supreme Court Justice Clarence Thomas, esteemed in conservative legal circles, or was certainly respectable, was in many ways one of the most central players in all this. Your previous guest, the Secretary of State in Michigan, Benson, said everything is connected. And you were talking about those fake electors. Well, that was central to Eastman's game plan for blocking the election of Joe Biden as president, to claim that there were disputed electors. I mean, this is laid out in his memo. He wanted Pence to say, no, there's a dispute about who the legitimate electors are for these, 7 states. Therefore, we have to throw them back to the states. There's a dispute. Well, there was no dispute. It was totally made up. These were phony electors, clearly, but it was central to the Eastman strategy. So in many ways, Eastman lays out in these memos he wrote, there were 2 of them, sort of the game plan for the coup, as it were. And, everything that took place in the run-up to that was part, including, in fact, most centrally, the appointment of these fake electors, in order to advance that strategy.
Yeah, the legal theory, just to be clear here, the legal theory is because the Electoral Count Act contemplates disputed electors. It is something that had happened before in American history, particularly during Reconstruction. Because it contemplates that, the idea was it was kind of like an alley-oop pass. Like the states are going to throw the electors up in the air, and all Pence has to do is grab it and dunk it by being like, well, I don't know what to tell you here, guys. I'm not making a ruling. We got a dispute. We got 2 slits of electors in Arizona. That's what he's being urged to do by Eastman, precisely as the means of essentially overturning the election.
Exactly. And that's, precisely what Pence refused to do.
Yes,
I should say, the one precedent that Eastman was citing was Hawaii in 1960, when the original count had Nixon slightly ahead. There was a recount because the margin was so small. And, because that recount was ongoing, there were 2 sets of electors. As it turned out, John F. Kennedy won the state very narrowly, and it was those electors that were chosen. But that was a case where there was legitimately
a material change.
Dispute.
Yes, exactly.
It was a close election. There were 2, nobody was quite sure who was going to win the state. In all of these cases, there was really no dispute. The elections had been certified, and we knew who the legitimate electors were.
Yeah, they weren't showing up at the bank teller and saying, I'm Mr. Burns. Michael Isikoff, great reporting. Thank you very much.